I am Dr. Shipra Gupta, Assistant Professor, Department of Laws, Punjab University, Chandigarh. I am going to give presentation on the topic titled Protection in Respect of Conviction for Offences. Objective of this topic is to create awareness about the constitutional rights of the accused. Article 20 of the Constitution of India under Chapter 3 relating to fundamental rights exclusively deals with the constitutional protections and safeguards to a person accused and convicted under the criminal law. It provides for three protections to the accused, which are commonly known as number 1, the protection against ex post facto legislation, number 2, the protection against double jeopardy, and number 3, the protection against compulsion to give incriminating evidence. It means to say that Article 20 of the Constitution guarantees protection in certain respects against conviction to a person who is an accused of a criminal offence by prohibiting number 1, retrospective criminal legislation. That simply means a criminal legislation with retrospective application is barred. This is commonly known as ex post facto legislation. Number 2, punishment for the same offence more than once or double jeopardy. That means that nobody can be punished twice for the same offence. And number 3, compulsion to give self-incriminating evidence. Article 20 provides safeguards to the accused that replicate the natural justice principles of fair trial in the administration of criminal justice. Article 20, Clause 1 provides, no person shall be convicted for any offence except for violation of law in force at the time of the commission of the act charged as an offence, nor be subject to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. Article 20, Clause 1 provides for the first constitutional protection against non-retroactivity. The essence of non-retroactivity principle is that a person should never be convicted or punished except in accordance with previously declared offence governing the conduct in question. If the act, when done, was innocent and attracts penal liability by virtue of a subsequent law, would be prejudicial to the interests of any person. Article 20, Clause 1 limits the right of the sovereign legislature in a limited manner, and hence such ex post facto laws are regarded as highly inequitable, unjust, and contrary to the universal notion of fairness and justice. Article 20, Clause 1 is, however, restricted in its scope. This article in broad import prohibits conviction and sentence under ex post facto laws. This immunity does not extend to a civil liability and is restricted only to conviction or sentence. It applies to cases of retrospective increase of penalty for an offence. The expression penalty is used in narrow sense as meaning a payment which has to be made or a deprivation of liberty which has to be suffered as a consequence of finding that the person accused of a crime is guilty of the charge. It has been established by a number of judicial decisions that a penalty imposed by the sales tax authorities is only a civil liability, though penal in character. So, it is clear that under this article, an immunity is provided to a person from being tried for an act under a law enacted subsequently, which makes the act in question unlawful. If an act when committed is not an offence as per the law in force, no future law can make it an offence. Every law that takes away or impairs a vested right is considered to be retrospective, hence attracts the application of Article 20, Clause 1. An ex post facto law that only mollifies the rigor of a criminal law or reduces the penalty does not fall within the prohibition under Article 20, Clause 1. That means to say that if a subsequent law has the effect of reducing the penalty and is for the benefit of the accused, this article has no application and the accused shall be entitled to the subsequently reduced penalty. As a natural corollary, the acts committed prior to the enactment of law in question would be prejudicial to the interests of any person if the act when done was innocent and attracts penal liability by virtue of a subsequent law. It is further important for the application of this article that the act should be an offence under the law in force at the time of the commission. Hence, no one can be punished for an act which was lawful according to the law in force when done, that is, at the time of commission but made unlawful subsequently. There is no fundamental right available to a person accused of the commission of an offence to be tried by a particular court or by a particular procedure unless there is involvement of any constitutional objection by way of discrimination or the violation of any other fundamental right. Retrospective change in the venue of trial does not attract the application of Article 20, Clause 1. So, it can be summed up that the protection under Article 20, Clause 1 is restricted only to criminal liability, conviction or sentence, applies only to retrospective increase of penalty and does not give right to the accused to be tried by a particular procedure or a particular court. Retrospective change in the venue of trial does not attract the application of Article 20, Clause 1. The second constitutional protection guaranteed under Article 20, Clause 2 is against being prosecuted and punished for the same offence more than once. Article 20, Clause 2 states, "No person shall be prosecuted and punished for the same offence more than once." This protection against double jeopardy incorporates the common law plea of authorize convict. It bars the retrial of a person when convicted and sentenced for the same offence. Only where the accused has been both prosecuted and punished for the same offence, a second trial is barred. Article 20, Clause 2 is based upon the principle of double jeopardy clause and lays down that no person should be put in jeopardy of his life or liberty more than once. Article 20, Clause 2 uses the word "and" in conjunctive sense, and it is only where the accused has been both prosecuted and punished for the same offence a second trial is barred. In order to attract this article, it is required that number 1, the person should be accused of an offence, and number 2, that he should have been prosecuted and convicted before a court or a judicial tribunal. It must be noted that the scope of Article 20, Clause 2 is narrower than the English or American rule of double jeopardy, as it does not incorporate the common law plea of authorize acquit. Its ambit is only restricted to authorize convict. In that sense, if a person has been prosecuted for an offence but acquitted, then he can be prosecuted for the same offence again and also punished. It is essential for the application of this article that prosecution and punishment should have been before a competent court. The article does not give immunity from proceedings other than proceedings before a court of law or a judicial tribunal. A government servant who has been punished for an offence in a court of law may yet be subjected to departmental proceedings for the same offence or vice versa. The Supreme Court in Director of Enforcement versus MCTM Corporation Private Limited in the year 1996 has clarified that the proceedings before the sea customs authorities or the adjudicatory authorities functioning under the Foreign Exchange Regulation Act are of adjudicatory nature and character and are not criminal proceedings. It is, however, pertinent to note that this protection cannot be availed if the previous acquittal or previous trial becomes abortive due to inherent defects. A trial under Article 20, Clause 2 is not barred when the previous trial has become abortive either by virtue of some inherent defect or illegality affecting the validity of the trial itself, for example, lack of jurisdiction, etc. It has been clarified by the Supreme Court in Kalavati versus State of Himachal Pradesh in the year 1953 that an appeal against an acquittal is in substance a continuance of the prosecution. Hence, the protection under Article 20, Clause 2 cannot be pleaded against the appeal. The Bombay High Court has, however, further observed in Jitendra Panchal versus the Intelligence Officer in the year 2008 that Article 20, Clause 2 to be operative, both prosecution and punishment must coexist when the second prosecution and punishment is for the identical offence for which the person concerned had already been prosecuted and punished earlier. The same offence would essentially mean the offence whose ingredients are the same. Double punishment is not barred if there are two distinct and separate offences with different ingredients under two different enactments, notwithstanding that some of the ingredients of the two offences may be common. This was held by the Supreme Court in the case of State of Bihar versus Murad Ali Khan in 1989. Judicial interpretation has elaborately clarified in Jitendra Panchal versus Narcotics Control Bureau in the year 2009 that a person liable by any Indian law to be tried for any offence committed beyond India is to be dealt with under the provisions of the CRPC, having regard to the fact that the provisions of the code would also apply to any offence committed by any citizen of India in any place within and beyond India. If the offences for which a person had been tried and convicted in the USA and for which he is now being tried in India are distinct and separate, and it will not attract Article 20, Clause 2 of the Constitution of India. Now, the third constitutional safeguard guaranteed by Article 20, Clause 3 to an accused is the right against self-incrimination. Right to silence is implicit in protection against self-incrimination. The right to refusal to answer questions that may incriminate a person is a procedural safeguard which has gradually evolved in common law and bears a close relation to the right to fair trial. This constitutional privilege has been given to the accused in order to safeguard his right to privacy and to ensure the civilized standards in the enforcement of criminal justice. The Supreme Court in Selvi versus State of Karnataka in the year 2010 observed that the rule against involuntary confessions is to ensure that the testimony considered during trial is reliable, thereby ruling out the chances of miscarriage of justice. If an accused is compelled to speak under compulsion, It might be used against him and might also be injurious to his interests. In another landmark judgment of Nandini Satpathy versus P.L. Dhani, the Supreme Court in the year 1978 commented on the significance of right against self-incrimination, taking into consideration the reality of custodial torture for eliciting information pertaining to the alleged accusation. The right against self-incrimination has been viewed as an essential safeguard in criminal procedure. It was thus pointed by the Honorable Court that in the absence of such protection, there is likelihood of the accused being subjected to the third degree treatment so as to entrap him into fatal contradictions. Article 20, Clause 3 has exalted status in our Constitution. This constitutional protection, as provided by Article 20, Clause 3, makes it very clear that no person accused of any offence shall be compelled to be a witness against himself. This right is very important because whatever a person says may be taken down and used as evidence against him. There are various facets of right against self-incrimination that emanate from the principles of criminal law. The first such principle is that the burden to prove the guilt of the accused is on the state or the prosecution. The accused is presumed to be innocent until proved to be guilty beyond any reasonable doubt, and lastly, that the accused has the right to remain silent and that he cannot be compelled to incriminate himself. There are three main components of Article 20, Clause 3, and they are as follows. Number 1, it is a right pertaining to a person who has been accused of an offence. Number 2, it is a protection against compulsion to be a witness, and number 3, it is a protection against such compulsion resulting in his giving evidence against himself. Judicial interpretation has elucidated the ambit of right of self-incrimination in a number of cases. The Honorable Supreme Court in State of Bombay versus Kathi Kalu Ogat's case in 1961 was of the view that the person should be accused of an offence at the time when he makes the statements but cannot avail the privilege of this safeguard if he becomes accused after making such statement. In another case, MP Sharma versus Satish Chandra, the Supreme Court in the year 1954 further clarified that for attracting the benefits of this article, there should be formal accusation levelled in the form of first information report or complaint relating to the commission of an offence before a magistrate competent to try the offence. This privilege is available even to an incorporated body if accused of an offence. The expression "to be a witness" has also been judicially interpreted in a number of significant decisions of the Supreme Court. In MP Sharma's case in 1954, the court said that witnesses comprises both oral and documentary evidence. To be a witness tantamounts to furnish evidence. No person can be compelled to furnish any kind of evidence which is reasonably likely to support a prosecution against him or may have the bearing on the controversy with reference to the charges against him. Again, in Kathi Kalu Ogat's case, while reconsidering the issue, the Supreme Court observed that to give his specimen signature or handwriting or the impression of his palm and fingers, even though amounts to furnishing evidence in the larger sense is, however, not included within the expression to be a witness. The protection afforded to an accused in respect of testimonial compulsion is not limited to the stage of trial in the courtroom, but may well extend to compelled testimony even previously obtained from him outside the court. In Selby's case in the year 2010, the Supreme Court further said that forcible administration of scientific techniques or tests like narcoanalysis, brain electrical activation profile and polygraph tests during the course of investigation would be unjustified intrusion into the mental privacy and would be violative of the right against self-incrimination. The protection of Article 20 Clause 3 does not extend in certain situations like number 1, when the police officer investigating a crime against a certain individual merely asks him or her to do a certain thing. Number 2, when an accused is compelled to stand up and show his face for the purpose of identification or to merely make a statement while in police custody. In case of a passive submission to search can also not be regarded as a compulsion if during search anything is recovered which may provide incriminating evidence against the accused. It does not extend to the parties and witnesses in civil or other proceedings. It can be concluded that Article 20 is a compendium of constitutional protections to a person accused of an offence or facing a trial. In the administration of criminal justice, protection against ex post facto legislations or retrospective criminal legislations, punishment for the same offence more than once or double jeopardy and compulsion to give self-incriminating evidence are significant, keeping in view the serious ramifications of the criminal proceedings against a person. These protections emanate from the presumption of innocence of the accused until the guilt is proved beyond any reasonable doubt. That means to say that a person cannot be considered to be a criminal unless his guilt has actually been proved by the court of law. It is a fundamental right of every accused to claim these constitutionally guaranteed protections throughout the course of trial. Unless a person is aware of his rights, it is not possible for him to claim the same. It is further obligatory for all those who are involved in the law enforcement to ensure these rights to all the accused. The duty of the state remains very crucial in order to provide these rights to the accused in a meaningful manner so that any person who is affected thereby should be brought to their knowledge that he is entitled to certain rights which have been given by the Constitution of India. The judiciary on its part has undoubtedly played a major role in the interpretation as well as implementation of these fundamental rights. Judiciary, by its constructive interpretation, has tried to do away with the ambiguities, thus making these rights more meaningful. Some of the landmark judgments have changed the course of criminal justice administration. Like after Selby's case, all ambiguities about the use of scientific techniques have been cleared out and has established the legal position with regard to the same as intruding the mental privacy. It has been regarded as degrading, inhuman and violative of right to liberty. In Kali Kalu Odak's case also, it has been very nicely expounded on the expression to be a witness by the Supreme Court. Article 20 also incorporates the natural justice principles of fair trial in the administration of criminal justice. By virtue of the Constitution 44th Amendment Act 1978, Article 20 can not be suspended even during a national emergency, meaning thereby that any person can not be deprived of all the rights which are provided by Article 20 to any person, even in case there is declaration of national emergency in the country. Keeping in view the sanctity of the constitutional rights guaranteed to the accused, it becomes the responsibility of the state to ensure the protection of these rights. However, it is a matter of concern that those who are responsible to give protection of these rights are the only ones who are violating these rights. It means to say that Article 20 of the Constitution guarantees protection in certain respects against conviction to a person who is an accused of the criminal offence by prohibiting retrospective criminal legislation or by punishment for the same offence more than once or double jeopardy, that no person can be punished twice for the same offence, or giving protection against the self-incriminating evidence. Article 20 provides one of the very important safeguards to the accused that is very important for the protection of all other rights of that person. It has further been clarified that the confession should appear to have been made voluntarily, and the police officer recording the confession should satisfy himself that the same was being made voluntarily by the maker of the statement. It is a common fact that the police atrocities are commonplace and there is a check on the police actions. The person who is in the custody of the police, no person outside would come to know what kind of treatment has been meted out to him by the police. In case of hardened criminals or the ones who are involved in terrorist activities, the police, especially prior to Selvi's case, considered it to be legitimate to use the scientific techniques by compulsion. However, this case has changed the whole scenario. The custody of the police. Thank you.